Hello, everyone. This is Estelle Rogers. I'm the chair of the Standing Committee on Election Law, and together with the section of Civil Rights and Social Justice of the ABA, we are sponsoring this program called How to Run an Election the ABA Way. I just want to express our appreciation to our co-sponsors, which I'll run through very quickly: Coalition on Racial and Ethnic Justice, Commission on Sexual Orientation and Gender Identity, the Commission on Disability Rights, Commission on Hispanic Legal Rights and Responsibilities, the Criminal Justice section, and the State and Local Government section. So you know who's contributed or shown support. And the most exciting part of who's shown support is I want to take this opportunity to introduce to you the president of the American Bar Association, Patricia Refo, who has shown tremendous interest and enthusiasm on subjects related to voting, as she will tell you right now. Trish.
Thank you, Estelle, and thank you everyone for joining us on this really important and obviously very timely webinar as we prepare for extremely important elections this November. Estelle, a special thank you to you and to the Standing Committee on Election Law, as well as to the section on Civil Rights and Social Justice and their chair, Angela Scott, and to all of your staff for the work that all of you have done on this program, and for leading the initiative that we're about to talk about, the Poll Worker Initiative, and creating a lot of outstanding resources for the legal community to talk about our role and responsibility as lawyers in this important moment as we near an election. I'm very excited that with the partnership and help of Estelle and the Standing Committee, we have just launched a wonderful program called Poll Worker Esquire, Poll Worker ESQ. It is co-sponsored with the National Association of Secretaries of State and the National Association of State Election Directors. And it is designed to encourage lawyers and law students to serve as poll workers this fall. Poll workers, of course, are an important component part of ensuring free and fair elections. And this year we have, obviously, an added obstacle, which is an incredible public health emergency, the pandemic in which we all are living, and finding folks who are not in the highest at-risk categories to serve as poll workers is extremely important. So this is an opportunity for lawyers and young soon-to-be lawyers to step up and serve their communities. I want you to take a minute and visit www.canivote.org, which is a terrific website of various election resources around voting, and click on Become a Poll Worker, because that tab will take you to information from your local jurisdiction, your state, about how you can serve. Depending on the jurisdiction, you could be asked to staff a polling place, you could be asked to process returned ballot envelopes, or any number of other tasks. And particularly in a state like mine that permits permanent voting by mail, in also called absentee voting, some places else, there may well be jobs you can do that are not on election day, jobs in advance of election day, to help move forward a free and fair election. It is hard to imagine anything more important right now than that. The sacredest moment, if that's a word, that we have in our democracy is that quiet moment when each of us is either in a voting booth, or in my case, because I always vote by mail, in the quiet of my kitchen, making the choices that each of us as citizens has to make in an election. So please be part of the ABA's initiative to make sure all goes well this November. So please vote and please serve as a poll worker. Thank you, Estelle.
Thank you, Trish. We really appreciate having you here. And I know firsthand that you are very passionate on this subject. So we're glad about that too. Thank you. So let's get started with our program. I have one or two introductory matters, I guess it's really one. One of our panelists has unfortunately been detained and may not be able to make it at all on this panel. We're very sorry to hear that, but she's being deposed and we didn't want to get in the way of a legal order. Her name is Megan Wolf and she's the Director of Elections of Wisconsin. She's been on a webinar with us before and she's very good and presents a perspective that the rest of us unfortunately don't really have. So we're sorry not to have her. I'm hoping she'll pop in late, but if she doesn't, we're going to try to improvise a little bit and cover the materials in any event. So I am the moderator and I am the chair, as has been mentioned, of the Standing Committee on Election Law. The committee's been around since the 70s and we operate very much by consensus. It is by design a totally bipartisan and usually evenly split committee by party. The members represent a broad spectrum of politics and of legal approach and have proven, I think, over the years that we can work together and make some real progress on setting down some standards and some policies that work well for elections for everybody. So that's the program. And the panelists you will see are Chuck Bell, who is a senior partner at an LA law firm, Jason Kaune, who is a partner at a San Francisco area law firm, Paul Smith, who is the VP for Litigation and Strategy at the Campaign Legal Center and also teaches at Georgetown Law School. And Megan, if she comes, is the administrator of the Wisconsin Elections Commission. So the centerpiece of this program is the ABA Election Administration Guidelines, which have been drafted, redrafted, revised, re-revised over a number of years. We just re-adopted them in the ABA House of Delegates. You should have them. You should have gotten them with your instructions for getting on this webinar. The guidelines, as I say, were recently re-adopted. Sorry about that. Were recently re-adopted, and that was just in a month ago, almost exactly. And they are updated in several respects, but the most important ones, I think, and the most timely ones are one, voting in emergencies, which has obvious salience, absentee ballots also, and purging or the maintenance of voter rolls, which has also had some controversy over recent years. And I think we've sort of pinpointed the most interesting and controversial matters, though there will be some other matters that will be treated as we go along, though mostly the other themes are going to be mostly at the end. So if we get through all the three major themes, we'll be fine. All right, I'm not finding my, I'm sorry, everyone. I'm not finding my slide clicker. Allie?
You just
Allie?
move your mouse. I think it should work.
Yeah, that's what I'm doing. There it is. Sorry. Okay. The first issue that we want to talk about is maintenance of voter rolls. And I'm going to turn it over to Paul Smith, who's been very involved in this issue for several years. And before I do, though, I want to say that we are planning to run this webinar fairly informally. We all have a lot of knowledge and experience in voting issues. And so we're going to allow anybody who wants to interact with Paul to do so. And we'll see how that goes. Paul. You're muted, Paul.
Thank you, Estelle, and thank you all for being here. It's a pleasure to be talking to you about this important issue in an election year of some notice. Maintenance of voter rolls. Voter rolls are the list of registered voters that nearly every state maintains. In North Dakota, they don't have registration, but everywhere else you register. In some states on the same day you can, but generally speaking, you would register in advance. And to give you a little background leading up to the Husted case here, under the National Voter Registration Act, Congress tried to regulate the way that states maintain their voter rolls in a balanced way to achieve two different objectives. One of which was to push the states to maintain them as an accurate list, and not allow them to get old and bloated as they had done in a number of states over the years, with people dying or moving out of state and not being taken off the rolls. You could end up with twice as many people registered to vote as there were voters in the state. And so the federal act does require that states actively maintain their voter rolls and purge people from them who don't belong on them anymore. At the same time, it says we want to protect people from purges that are done for the wrong reason or without justification. And so the act, the National Voter Registration Act, lists specific things that can justify purging somebody from the voting rolls, like moving to a different county or state, or dying, or getting a felony conviction in a state that has felon disenfranchisement, or being declared legally incompetent and unable to vote. And it then specifically says one thing that is not a reason to take people off the rolls is failure to vote. That is barred as a justification for purging people from the voter rolls. And this was a change because there were states traditionally that had this use it or lose it policy that said if somebody doesn't vote frequently enough, we're simply going to toss them off the rolls. And the Congress, in its wisdom, said you have a right not to vote, and it enshrined that in the statute. So then what happens? Ohio was a use it or lose it kind of state until it came under the federal regime. I guess I need to back up and explain that under the act, before you can be purged, they have to go through a confirmation process. They have to send you a confirmation notice, which you can return and tell them you're still out there and you're still eligible. But if you fail to return it, they have to wait 4 more years, two federal election cycles before they can actually purge you from the rolls. So that's a built-in requirement as part of the process by federal law. So what Ohio did is said, we're going to trigger that confirmation process and send those notices out to anybody who doesn't vote for 2 years. So anybody who simply doesn't vote in a federal election for 2 years or state election, or have some other contact with the state, gets a notice, confirmation notice, and when they don't return it, which most people don't, 4 more years, you get purged from the rolls. And this was challenged in the Husted case on the theory that this system effectively is purging people for not voting for 6 years. And that while there is a notice that is sent, that doesn't really justify putting people into the process of simply not based on non-voting. What Ohio said was we take the initial 2 years of non-voting as evidence that you're moved out of the county or state because you would have voted otherwise. And then we go through the federally mandated confirmation process, and 6 years later, 4 years after you send the notice, if you don't get it back, we're going to purge you. And so there I was arguing about this incredibly complicated statute in the Husted case in the Supreme Court. And as happens with many cases, I lost 5-4. The more conservative wing of the court said what Ohio was doing was perfectly okay. That the minimum requirements of the statute were you send that confirmation notice and you wait 4 years. And Ohio was doing that. And even if it had a totally irrational reason for initiating that process, concluding that anybody who doesn't vote for 2 years has moved out of state or out of the county, we don't care. Congress didn't address that. People are not being purged solely for not voting because they're being purged for not voting and not returning that notice. And that's okay with Justice Alito, 4 dissents. So then we should probably, I guess, Estelle, address what the guidelines say about this. The ABA has to say about this. And essentially what it does is it disagrees with the outcome in Husted, or at least says that states should not exercise the right that they were given in the Husted case to initiate this purging process simply based on non-voting. They say in 2.3, as you'll see here, failure to vote should not be the reason for initiating the voter verification process. It may not be a factor in canceling a voter's registration. So under that guideline, Ohio's process, which initiated the voter verification process based simply on not voting for 2 years, would be in conflict with the guidelines. And so we go on to explain in the commentary here that a person's failure to vote should not raise an inference that the voter is moved or is otherwise ineligible. Lots and lots of people, after all, vote only infrequently, but haven't gone anywhere. And that, for that reason, the state should have some indication that somebody's actually moved or died or whatever. And there are ways to find out. People post forwarding addresses with the National Change of Address database, or maybe you send them mail and it comes back addressee unknown. But absent some sort of indication like that, say the guidelines, you shouldn't simply start this process based on non-voting.
Can I just jump in for 1 second, Paul?
Sure.
In terms of the guidelines, the guidelines, as you can tell from this very obvious example, are not designed to be a restatement of the law as the Supreme Court or any other court or statute deems desirable. It is what we deem desirable. That's why they're guidelines. We, I think by a unanimous vote, our committee decided that, notwithstanding that case, that we think the better policy is that the process should not be triggered by failure to vote. And that, and that's what we note here quite up front, that we disagree with the Supreme Court and this is our suggested policy. Back to you, Paul.
Thank you for that clarification. Yes, I think that the guidelines are quite clear that they acknowledge that this puts more restriction on the state than the Supreme Court has allowed by allowing non-voting to not. The Supreme Court has said it can be a trigger. The guidelines say otherwise, I think that's much the better policy. I'm involved in a case in Georgia where we did a survey of people who haven't voted in 6 years. And the vast majority of the people surveyed hadn't moved anywhere. They simply were not voters. Just to close out this part of the seminar, the guidelines go on to address sort of openness, transparency about how this process works by saying that election authorities should maintain all records related to voter verification activities for at least 2 years and make these records available to the public. Everything ought to be fully transparent, and lists of who's been canceled ought to be available so that everybody knows what's going on. Also, really obviously good policy. With that, Estelle, I think we can move on to the next topic, unless there's questions or comments.
Yeah, I think your co-panelists might have things to say about that. Anyone?
Well, this is Chuck. I'll jump in. I thought Paul did a really nice job with that presentation, and I know that he's a distinguished litigator, and that was a very interesting case before the Supreme Court. Just a few things. We have a very complicated interplay between the federal and state governments in our system. That's no surprise. It exists in a lot of other circumstances as well. And NVRA, when it was adopted in the 90s, was kind of an overlay on this, which attempted to establish sort of a consensus of encouraging of full participation, as well as encouraging states in a uniform way to maintain the rolls. One of the important things that the HAVA amendments did was to provide for the requirement that states adopt and maintain the voter rolls, which slightly modified some of the functions between state and local governments, which, for example, in California, the counties had been the level of government which did the most work in maintaining the voter rolls. So we have this complex interplay. We have a statute which really hasn't been amended for nearly 20 years. And as in every other context in modern life, the means of communication and so forth have changed dramatically. So some of the elements, in my view, of NVRA and HAVA in terms of voter list maintenance procedures are probably outdated and need to be rethought in terms of how this can be done more effectively. One of the big reforms that was really initiated by the Pew Foundation and resulted in a system called ERIC, which is a multi-state compact, if you will, of a number of participating states which share information through a clearinghouse, ERIC, which then provides that information back to the states to enable them to undertake these notification and functions, particularly attempting to actually, one of the most important things is to encourage people who have not re-registered when they've moved, particularly outside the same county, but within the state or even out of state, to update their registration so they can participate in the electoral activity where they happen to live. And one of the things that NVRA does in that respect is to acknowledge the opportunity for use of by state election officials of the postal change of address, but also collective operations like ERIC to engage in that process. The other thing I would say is states and local jurisdictions have a multitude of ways in every election cycle of communicating with voters. Some of those ways, even when they get information back about being undeliverable mail and that sort of thing, may not be used for purposes of this purging procedure that Paul referred to. For example, in California, we encountered a situation where the Secretary of State in 2019 updated its NVRA manual, which is a very helpful document provided to the counties on what they can and can't do. And it's almost mind-numbing when you look at whether the mail that is sent as official election mail can be used for purposes of this notification requirement. So I just use that to point out that as usual, the law trails practice. There's a lot of information which is available that may actually be useful to election officials and to voters as to their whereabouts that might enable the election officials to locate them and make sure that they're on the voter rolls in the place where they actually reside.
I might just add a little bit more looking at this Wisconsin slide. What it illustrates is that you get lawsuits when you're an elections administrator from sort of both sides, those who are trying to prevent you from purging people based on things that they don't think are sufficient, like the Husted case where I was saying non-voting isn't the basis for initiating the process, and those who want you to purge more aggressively. That's what was going on in Wisconsin, where there was a fight about how quickly the election commission was putting 129,000 people off the rolls, or whether they were doing it too slowly, allowing people to continue voting in the meantime if they wanted to. This often is based on different political calculations about what's good for one party or the other. But it is basically, there is a way in which you almost can't win on either side if you're trying to run the railroad in this area on the issue of purging.
I agree. Election officials are being tugged in both directions.
Yeah.
It's not an enviable
Jason?
job anymore.
No, that's
Sorry.
right. And Estelle, to the guidelines, we spent some time trying to find the balance. And in one part of the guidelines here in the slides are the role of the public in intervening. I mean, what Chuck just described is true. It's amazing that outside of the federal general framework, how differently the states view this process. We had a chance recently to look at what they do in Kansas, and they view it as a very ministerial process, very little interaction. And yet, as Paul was just saying, lots of people, interest groups and others are interested in this process and want to assert themselves in it. And Wisconsin, in its statute, has the ability for outside parties to sue over this process. And that's this case going to the Supreme Court, which Megan may be talking about right now. And so
We're not sure what she's being deposed on, by the way, for the record. We really don't know what the case is. You wouldn't tell me.
Well, there's several. There's the Supreme Court case, and they've got a federal case going. But in any case, as Chuck was saying, Wisconsin is a state that uses the example of using ERIC as the trigger, and then either waiting a certain amount of time, which is state policy, to remove voters, or the lawsuits over how quickly that should happen. The last thing I'd say, Estelle, about the balance of the policy, because of what you just explained, the policy is sort of a collective point of view for starting point for jurisdictions to look at. Paul, I can imagine, because you can read it in the text, the heat over the argument of whether a trigger is a reason. In other words, can something that brings something to your attention, court said that's not the sole reason. So we use the language reason here and recognize the Supreme Court case. But as Chuck was explaining, there are many other ways to trigger this process.
It was quite a heated argument indeed, Jason.
Yeah, I can only imagine.
Let me also mention, just as a matter of commentary on how public policy is made, that the ERIC system was developed by the Pew Foundation, or some sub-part of the Pew Foundation. It hasn't been all that long ago. It was in probably the last 10, 15 years at the most. And, you know, it was just a bit of a flyer. You know, they sort of thought, gee, if states were to compare their voter rolls, especially adjacent states, but not only adjacent states, you could probably find a lot of moves without much trouble. And it just sort of took off. I mean, you know, a few states joined it at first. Now, I think it's 30 or more of the states share information this way. And it's been found to be very reliable and a great public-private partnership. It was a great innovation, and I'm glad that states have really adopted it.
And on the bipartisanship of that, Estelle, I think we spent a lot of time, the section 2.7 on public records. The law does not require a lot of transparency in this process. And I think from both right and left, there's an interest in there being more access to the information, just even a posting by secretaries of state what the process is. Sometimes that's held close to the vest. So I think sunlight on the process can help it.
Yeah, and I think you'll find when you look over the guidelines, people who can wade through the 22 or whatever it is pages, you will find a lot of places where our guidelines mandate that records be kept for 2 years in many cases, so that one could look at how these processes are being administered. And that's sort of a common thread that runs through the guidelines, having to do with transparency and public access, which we recommend. So let me just move on a little bit. We're skipping absentee voting for the moment and want to move right over to emergency management of elections, which will be led by Chuck Bell.
Well, this subject obtained an entirely new focus this year for obvious reasons because of the COVID emergency. A number of different groups, informal groups, such as ours, have been very interested in it. So what the ABA Standing Committee on Elections did was to provide some fairly general guidelines, and a number of other groups have suggested even more detail. These include groups of law professors, combination of lawyers, professors, and election officials, all of whom contributed to the thinking on this. And I guess the essence of our proposal is that it's essential for all jurisdictions to have a plan for the emergency management of elections. Probably the most common, or maybe the most common before COVID, had to do with floods or emergencies such as 9/11. As you know, the New York elections were being conducted on 9/11, which was a huge disruption to the electoral process. We outline in our plan we urge jurisdictions to develop, enact, and disseminate written plans so that the public is aware of how this might these plans might affect them and have some opportunity for input. We provided in section 11.2 a number of points about what those emergency plans should include, including, alternate locations, times, place, and manner of conducting elections, and as well as a clear designation of who has the authority to provide these plans. We've seen very different approaches to that in the different states. Some states enacted emergency plans in their constitution and laws that provide, for example, the governors a very broad power to enact plans, even override statutes with respect to all manner of subjects, and they've been used for overriding election administration too. Providing and preserving the data, which is a problem when you have things like floods or fires or earthquakes or disasters of that sort. And then provisions to deal with how voting equipment would be used, what kind of voting you might have. And one of the biggest issues that we're looking at right now in many states is, will states that have not been vote by mail or absentee voting states really convert to a much more significant or complete voting by mail. Developing communication plans, training poll workers to fill in the event of an emergency, and dealing with people who may require additional assistance due to language or disability in voting. How will that be conducted? Our guidelines are fairly general, but they raise a lot of issues, which I think at least are important for the public to understand. How will elections be managed? I will say that this is a subject of a lot of litigation as we speak in a number of states. It happened before the primary elections in the spring. Some of those lawsuits are still going, but there's new litigation that seems to pop up every week on this. And I think that the question really is, how do you deal with this? Because really, elections are fundamentally bureaucratic endeavors. They're conducted by election officials who are often pretty small operations in comparison with other governmental agencies that operate on an ongoing basis. They have a task to, register voters, maintain the voter rolls, and to conduct these elections several times a year, and election years for sure, but even more elections when you take local elections into account. We've been a predominantly vote at the precincts country, although that's changing rapidly. And the issue of how you conduct vote by mail elections now and how you deal with precinct voting or local in-person voting is a huge issue, not only for election administrators, but also the culture of voting within a particular state. So all of these are factors that election officials in developing these plans need to take into account. The challenge this cycle is that some of these rules are very new, and the COVID situation itself presents problems for in-person voting in a manner that the public is satisfied with, willing to go in person to vote. So this increase in voting by mail is not surprising, and in some ways will be important to assure that as many people as possible are able to exercise their franchise. But at the same time, there are people who may not be familiar with voting by mail, more familiar with precinct voting, who also could potentially be disenfranchised. So some states are looking at ways they can enhance precinct voting or vote center voting, which I think we're going to talk about as well, and voting before the election, which is an increasingly common practice in every state at vote centers or places that are not necessarily in your neighborhood, but are supposed to be reasonably accessible. And indeed, our proposal or our recommendations have enhanced the element and some suggestions as to how vote center voting and early voting would be conducted. I'll stop there.
So,
Now that you brought it up, well, why don't you talk a minute about vote center voting, since that's one of those things that I think has, especially lately, received a lot of attention with the sports arenas being proposed as voting places.
Well, that's an interesting development. Jurisdictions that have adopted vote centers are always, of course, looking for locations that are accessible, that are located geographically in places that voters can access, and in some instances are located with some data information to be located in places where voter turnout has been lower. So as a means of trying to encourage people to vote who might not have voted otherwise at accessible locations that are known to the public. So our guidelines are pretty straightforward. We urge the jurisdictions to make those vote centers connected electronically with their election headquarters for the jurisdiction, to allow people to come in and vote there and be able to vote an appropriate ballot, to resolve registration or re-registration issues and update their registration information at the same time as allowing them to vote either a regular ballot if those issues can be resolved, or a provisional ballot if they cannot. I think the advent of vote centers and the promise of this approach is that with that kind of electronic connection to the election office, a lot can be done on a one-stop basis, although it does pose some challenges for election administrators to update the registration stuff at the same time as they're trying to facilitate voting at those locations.
Let me just mention, because Chuck raised one thing that I think a lot of people question, and that is that if you're at a vote center, in other words, not necessarily right where you live or very close to where you live, there would be people there from many different precincts. You can imagine it in a sports arena. And how do they guarantee that you get the correct ballot? Well, as Chuck implied, there are electronic means, and everything's connected to the election headquarters, the supervisor of elections, or whatever they call it in your particular jurisdiction. I know that in Florida, where I've had some experience there, when they have early voting, they only have certain places open. Almost everywhere when they have early voting, they don't open every precinct. In Florida, it at least used to be, excuse me, public libraries. So when you went to your public, and it could be any public library, not even one anywhere near you. It could be near your work. It could be near nothing that's of significance to you. When you go into the public library, they ask for your address and they are able to generate the correct ballot. So it's clearly doable, and that's been going on in Florida at least for years. And I imagine, there are people who question how this could be done correctly, but somehow they manage. And with this pandemic and needing big open spaces for voting, which is obviously one of the things people are worried about voting in person, I think these sports arenas could really be a new trend.
Well, I agree. I think one of the issues that we were facing back when HAVA was enacted in 2002 was, we didn't have this sort of connected system that would allow much of this to be done remotely. So, for example, you'd print a ballot and you would send it out to a precinct, and there it would be. Someone shows up, they're at the wrong precinct. HAVA encouraged the use of provisional voting so that those people would not be turned away. But the natural limitation was you might not have the ballot at that precinct that would be the same as one that you would use at your correct precinct if you were not at the correct one. Electronics have facilitated the ability of these vote centers to actually produce the ballot type that would allow your ballot to be cast for all the offices that you would be otherwise entitled to vote on, which I think is a plus. There are some back end elements of that, getting the ballots into, the tabulation systems to allow them to be tabulated in the right precinct and so forth. But I think that one of the other things is just the professionalization of election administration and the cooperative work that organizations like the National Association of Secretaries of States and some of their local counterparts have done, is to provide a lot of information to local jurisdictions on how to do all of this better.
Thanks, Chuck. Jason, did you have something you wanted to add? I thought you looked like you did.
I'll just add to that. I think that we're in a time, just like we're learning how to work anywhere, and we're going to learn how to vote anywhere. And I guess I'll talk about that a little more when we talk about disabled voting. And then earlier, I was listening to what Chuck said and wanted to underscore the importance of having a plan, because what Chuck said is true. There's so much litigation happening on the state level in the wake of the primaries. And that's in part because those election administrators have to be the umpire, the starting point. There are going to be people with different views about, when things should be counted and how, expansive or concerned about fraud. But if you don't start with a plan, that leaves a little chaos for the court, because it is choosing between two viewpoints instead of against a plan. And I think we found that a lot of jurisdictions didn't have a plan.
I would just comment, Estelle, that this vote center idea has a lot of promise, because one of the problems we saw in the primaries was the closing of vast numbers of polling places at the precinct level, based in part on the fact that they couldn't get people to come to work. This was obviously happening very soon after the initiation of the lockdowns, without a lot of preparation time, and people were afraid to be poll workers. In part also because of the assumption that so many people would vote by mail, and you ended up with places like Georgia having massive lines, 4 or 5 hour waits to vote in some counties, even though a lot of other people were trying to vote by mail. The other thing that happened is the voting by mail systems were completely overwhelmed And so people were not getting their absentee ballots that they had asked for. And so, a lot of the litigation that's going on now is either trying to fix this in some way or make the vote by mail system work better. And so you see things about witness requirements for absentee ballots being waived because that's not consistent with people's concerns about COVID, or the opportunity to cure if your ballot is being rejected for signature match problems. A lot of these other issues are being fought out as we work in this weird world of massive increase in voting by mail. Plus, on the other hand, the need to maintain the opportunity to vote in person, which a lot of people insist on and are going to want. And there's a lot of fights about changing the deadlines for your absentee ballots because of the distribution problems. The system is very stressed, and the more ways we can add capacity and flexibility, the better.
Well, that brings us nicely to the next slide. As I said, I was going to jump around a little bit, but this is the subject of absentee voting, which I think Jason is going to help lead us through. You had that slide, Jason?
I do. Are we?
Okay.
Well, I actually think we've ended up covering and a lot of the topic that absentee voting is something people are discovering in ways they didn't discover before, and so the guidelines address them. And then Estelle, I think we have the slide up about the difference between absentee and mail-in voting, and I actually thought you were covering this slide.
I'm happy to.
Okay.
The answer is none. There is no
Yeah.
difference between absentee and mail-in voting. People who make the distinction are just not really looking at the definitions and the reality on the ground. There are states, and I think this is where mail-in voting, I think, got some currency, is there are states that are all mail voting jurisdictions, even they have some exceptions, but those include Colorado, Hawaii, Oregon, Utah, and Washington. I think actually Washington, D.C. might have just added that, Paul, do you know?
I don't think they're going to be all mail.
Okay. They just broadened the availability.
Yeah.
But anyway, those 5 states, interestingly, there are four of them considered pretty liberal states, and then Utah, but they have all sort of raved about these changes and been very gung-ho and shown levels of participation that are completely in another universe from most of the very deplorable rates of participation in voting that we see in other states. So I think that is going to be a new trend too.
So some of the people that try to draw this distinction, Estelle, sorry to interrupt, say there's a difference between absentee voting and mail voting because with at least the way it's done in the states listed here, they send the ballot to every registered voter without a request.
True.
That's right.
Says the president and others, you end up with ballots being mailed to dead people and people who've moved away, and that those ballots therefore are sort of rife with the possibility of being misused. Is that, in your estimation, a real problem?
Well, I think as usual in talking about voting and, all the dead people in the rolls and everything, the issue isn't how many dead people on the rolls are on the rolls, although we'd rather there were none. It's how many of those dead people vote. And I think generally speaking, if things go out to people who don't exist or who exist somewhere else, those ballots are not voted. I haven't heard anything to the contrary. I'm sure there are examples of fraudulent voting, and particularly interestingly, historically, it's been more apt to happen with respect to absentee ballots than in-person voting. But voter fraud, as most of us have heard for a long time in a lot of articles, is exceedingly rare. And the most recent example I recall of this was an election in North Carolina that had to be rerun because it's what they call absentee ballot harvesting. Somebody went around to people who had absentee ballots and assisted them, quote unquote, after they gave the ballot to this person. They said, well, let me help you fill it out. And then he filled it out. So that was, that was a problem, and it was rife enough. It was common enough that they had to run another election. But it's the exception rather than the rule. I do think, Paul, that's it's a good point about who sends what to whom, because there are, I think, a couple of states that in this particular time have decided to send absentee ballots and not just absentee ballot request forms to everyone. I know California is one of them, and I think there are a couple more.
Nevada
There are a bunch of
got
there are a bunch of Californians in this group, so we keep saying California. I apologize for that.
The Trump campaign sued Nevada after its legislature called for the same.
Right.
Yeah.
That's
And Estelle, if I can say sort of, I think there's insecurity and innovation here. I think one of the concerns Paul was asking about the absentee ballots that you see in a lot of voters is the change in culture for people in voting. There's a reason people like to show up, because they know the vote gets in and it's counted. And there is a larger insecurity about what's happening with those ballots, not only on their way to you, but from you to the elections officials. So I do think there's an insecurity factor. Because I'm going to guess we're not going to get to it, I want to give a shout out to Hawaii in this, because what mailing all these has done is forced some innovation. And after a little bit of litigation in Hawaii, what Hawaii's done is made an electronic version of the ballot accessible to those with sight challenges and other disabilities, because that insecurity factor happens when people need others to help them fill out that ballot, and the uncertainty, did I really vote the way I wanted to vote? And an approach like that. So in Hawaii, they built a system so that when you ask for your absentee and you've got a certain level of disability, you can get an electronic PDF, interactive, voice interactive that you can fill yourself in, and it gets in. So I do think there's the mail, one of the slides you had earlier, there's a lot of insecurity about what's happening in the mail right now.
Yeah, absolutely. I also wanted to mention on this slide, the no excuse absentee voting. That has actually been more an issue out in the public than it ever has been before. Also, because when you have absentee voting in most states, you can vote absentee, or if we call it by mail, for any reason or no reason at all. And in fact, in many places, you can become a permanent absentee voter. Those of us who do a lot of work on election day in other states often just put themselves on that list. I know I have, even though I much prefer voting in person. But no excuse, and so no excuse absentee voting, I think, is the law in the majority of states. In some states, they make you state a reason, and they're very restrictive in general. It's you are out of the jurisdiction, you are very ill, you're in the hospital, and one or two others. So people who, in COVID are afraid of being very ill, even if they're not yet, don't really have an excuse. I had suggested actually earlier at another webinar that what they should do is have election jurisdictions or governors deem COVID an excuse. But I don't know, and I think a couple may have, but I don't know how many have. So in some cases, they're very stubborn about needing an excuse for absentee voting. Who knows if that will last or not.
A number of states have allowed that as an excuse. On the other hand, Texas and Tennessee, at least, have a system where you have to be out of the jurisdiction, disabled, or over 65. And then you can automatically vote absentee. And there's been people pushing those states to allow people under the age limit to vote absentee, and they are resisting. There's a massive amount of litigation in Texas. It's in the Fifth Circuit now. Also went up to the Tennessee Supreme Court because those jurisdictions simply don't want people until they get to the ripe old age of 65 to vote absentee.
This is Chuck.
Paul's niche in all this is to tell us where there's lots of litigation, and he's fulfilling.
Doing most of it.
So. I thought so.
I just wanted to comment. I think just looking at this from the longer perspective, the trend toward absentee voting has been increasing nationally, and certainly in some states more rapidly than others. in part, again, because of the culture change. We're a convenience-oriented society, and voting by mail is a convenient way to do that. I confess I have not voted at a precinct since about 1978 or so, usually because I'm pretty busy on election day. And so it certainly has its convenience advantages. The problem, I think, is in this cycle that we're looking at a rapid conversion of jurisdictions which don't have the culture and whose election administrators have not had the experience of having a different mix of voting like this. So typically they've had, planned, how are we going to operate our precincts? How are we going to staff them? And, as absentee has crept in, it's kind of created an in-office problem of processing applications, getting the ballots out to voters, processing when they come back in, and so on. So it's been a real challenge, and I think some of the states have had real problems with that in the primary. And of course, the hope is that they learn from their experience and are able to adjust accordingly to meet whatever requirements of the law are at the moment. And the late changes are problematic for election officials because, as I mentioned, their bureaucracies are not big bureaucracies, and that may be a part of the problem. They have to work really hard to make things happen, and they have to get it done in a very limited amount of time. The public demands it. I was just going to say also that I think the problem that the Republicans have faced with this is that in some of the states like Nevada, actually they're sending these ballots out not only to people on the active rolls, but also on the inactive rolls. And the concern there is, ballots that may be, in mailboxes or in apartment mailboxes or who knows what, accessible to people other than the ones for whom they were intended. And I guess we'll see what happens with this litigation that's ongoing there. And it's changed a little bit from what it was in the primary, which is a wholesale enactment of new election laws in Nevada that made a number of changes. So,
and Chuck, that's why I'm encouraged by the experiment in Hawaii a little bit, is because I think you're right that the lawsuit's about witnessing and what do you do to make sure that ballot is from the right person, and we have the technology to do this, right? that we can verify who we are. So I'm very interested to see when we get out of this some of those experiments and comfort level with it, voting in a different way.
Let me just mention one other thing about poll workers. About people's nervousness about voting in person these days. Just as voters are nervous about voting in person and therefore are trending more and more toward voting absentee, poll workers and other employees of the election authority are very nervous about these places, of being in these places and being out in public. And that's why I'm just making a pitch, a bold pitch. Our poll worker Esquire project is so great because it's really encouraging people who aren't usually poll workers, and therefore, and in many cases, younger people, to be poll workers this time, especially because of COVID, but it's the kind of thing that people get in the habit of doing sometimes, and we might have some permanent poll workers of a younger demographic. Wisconsin again. We'll get let Jason jump into this one for a minute.
All right. This is the Wisconsin slide. Sorry, let me catch up.
Sorry, I didn't mean to catch you
Sort
off
my
guard.
slides. No. I've managed to sort up my slides here. And it's not showing up in my pile. This is the absentee ballot slide. Yeah. So
Yeah,
like
Wisconsin
we
on
said before,
absentee.
we don't know which litigation poor Megan is enveloped in right now. But Wisconsin has been ground zero in a lot. We watched it on the primary day. One of the lawsuits here is about all these issues about what to do about the absentee ballots, the ID requirement, the witness signatures, the returning and counting of absentee ballots. And so the last I saw on that lawsuit, I haven't followed it closely enough to know where it is, other than it's unresolved. And I think the court, is running out of time to make decisions before the election occurs. And Wisconsin is defending its system. I think the number here that stands out is how many absentee ballots were rejected under the current system. So that's under scrutiny of should things be loosened in a way so that more absentee ballots get counted this next time through.
Yeah, what
And
happened
that's the
was
kind of thing that's a public concern generally. You often hear these announcements by jurisdictions in the paper that they're planning to purge 150,000 voters from the rolls. And, how they know that ahead of time or project that ahead of time almost makes it seem as if that's what they want to do, rather than that's what's going to be justified by the facts. But I think, some of these numbers are shocking, especially given the narrow margins of a lot of elections that we're seeing.
what happened in the primary was people didn't get the absentee ballot in time to mail it on election day. And the federal court had said you don't have to have it returned by election day, but at least after the case went up to the United States Supreme Court, you had to have at least have it postmarked on election day. There was a time under the lower court opinion where you could actually send it in after election day, and the Supreme Court, that's an awfully extreme system. The district court had gone so far as to tell the election officials they couldn't disclose the election returns on election night because people were still going to be voting the next day, and they didn't want to have the late voting somehow be done while people knew where the candidates stood. So this 23,000 figure may not be repeated in the general election if the ballots get sent out in time, and therefore they aren't mailed too late, which is essentially what happened.
Yeah, that's another area where we're seeing a lot of last minute changes or requests for last minute changes. The fiddling with deadlines and the issue of postmarks and all those kinds of things, which, I think in many cases, because of the current health crisis, that a lot of that liberalizing of deadlines is probably justified, but the later in the game you announce it, the more confusing it gets to people. So, even if you make a good change, I think there's something to be said for making it early.
Yeah. And that's another culture change. People, Chuck has said it's been a long culture change of people voting more. It's also been a long culture change of people not thinking of election day as election day anymore, right? The earlier you're encouraging people to vote, the more that changes the dynamics of, when someone's actually getting those votes. And people are unsure about that, about whether they should be waiting till the end, and get the most information, or voting earlier. I think we're seeing massive shifts in when people are voting, when the election's actually happening.
That's true. So we're now getting to the more odds and ends part of our presentation. There were a lot of other topics that we wanted to at least run through that aren't our three major changes in the guidelines. Those, if you didn't catch, were elections and emergencies, absentee ballots, and what was the other one?
Purges.
Thank you. Oh yes, you. Purges. This next slide is about having a go-to person on election day. And for those of us, and I'm sure several of us have done a lot of election day in the field kind of work, this becomes an extremely important thing. And it's, I think, a new section in the guidelines as well. I can't remember if it's new or not, but the fact is that if you have a go-to person or a phone number where whatever comes up, you can report it and be sure that it's going to be acted on, that is really all to the better. A lot of jurisdictions tell you 3 different numbers to call if, for example, machines are breaking down, or if the place opens late, or if there are police hovering at the front door, or all kinds of things that do happen at polling places and that can easily be stopped. But if you have to be shoved around to 3 different phone numbers, they're not as easily or as quickly stopped. So I wanted to make a pitch for that innovation in our guidelines as well. Anybody have any thoughts about that they want to share?
It's a good practice. I think that the best practice is also one that allows voters or people who are having problems voting to readily identify that. Of course, if they go to a poll, again, if they're voting absentee, it's a different problem. But if they go to a poll and they're not on the rolls, or poll isn't functioning, or the equipment is malfunctioned or something like that, it's a real frustrating thing for voters not to be able to know how they can resolve it. They may not get the resolution they feel is necessary to allow them to vote, or they may get frustrated and leave the precinct without voting if their problems are not managed by the polling officials at that precinct. I think counties and jurisdictions have thought a whole lot about this and try to deploy as best they can. But as you know, sometimes problems pop up where you don't expect them to be. Unexpected problems pop up that you didn't anticipate. And you know, that's all part of election administration planning that we, among others, are trying to promote.
Right. And you know, one other good example, by the way, of something that can go wrong is that they run out of provisional ballots. We don't like to, we would rather have people vote by a regular ballot, but if they have to vote by a provisional ballot in order to vote, we certainly don't want the polling place running out.
Right.
So speaking of which, counting ballots. Paul, this is your slide.
Okay,
I thought it
well,
would be perfect for you.
the sort of series of nightmare scenarios that election lawyers are spending a lot of time talking about these days, and the problems, the potential problems could arise from a variety of things. If there's hacks, if there's power grids that go down or anything. But the main concern nowadays in the age of COVID and mail voting is how long it takes to count mailed-in ballots, particularly in states that aren't used to handling large volumes of mailed-in ballots. And you see a reference here to the fact that it took up to 6 weeks for election officials to count the absentee ballots in 2 New York primary elections with volumes of voting much lower than we're going to expect to see in the general election. And what you're going to see then, therefore, is the reporting of some returns on election night, but absent a very big differential between the 2 presidential candidates, probably not a declaration of who won. And that could be delayed for a week or more if it's close in some decisive state. The concerns are exacerbated by the fact that it is likely, given current polling, that the people who have voted in time to have their votes announced on election day will trend Republican, and the people voting by mail will trend Democratic. And so you start to see some of what we already saw in California and Florida in 2018, the so-called blue shift, as the count goes from a pro-Republican count to a pro-Democratic count, gradually, drib by drab, over a period of days, as they're counting these mailed-in ballots, which have to be opened by hand, have to have the verifications done, often signature matches and things. So it takes some time. And this could lead to, given the kinds of things that have been said about it, about mail voting, claims that what's really happening is that the election is being stolen. So you can start seeing lawsuits filed about the counting process even before it's completed, with people trying to shut it down and have declaration of who won before we know who have all the ballots counted. It is, and then if it's really close, you know, the recounts could be very ugly. And what this means is we could end up with an extended period of lawyers fighting over the election, like we had in 2000 in the Bush v. Gore election, or perhaps even much worse. And that's why Senator Rubio introduced this bill mentioned here to move back the so-called safe harbor date. I will save you all from going into the arcana of the Electoral Count Act and what the safe harbor date is, but basically it's a date on which if the state has resolved its election, presidential election, and the governor's been able to certify who won, if they do it before, in this case, it's December 8th, then the Congress is committed that they'll count those votes. And this actually played a big role in the Bush v. Gore analysis back in 2000. There's no particular reason why. It's 6 days before the meeting of the Electoral College, which is on December 14th. The Rubio bill would move both of those dates back to the end of the month. It's no real prospect that it's going to pass, but it makes a lot of sense actually to give these state processes more time to figure out who really won the state and to get over the inevitably large degree of chaos that may arise as counts take weeks to complete. All of this nightmare scenario may not happen. I read an article today that said Florida has a long history of very substantial mail voting and also has a long history of getting results announced on election night. They just know how to do it. And the author said, if, for example, Mr. Biden were to win Florida, no Republican has won the Electoral College without Florida since Calvin Coolidge. And so that would give people some sense of where the ultimate outcome is going to be. Maybe that would cool everything down a little bit. That's just an example of how it could play out. But it is a concern in a time of great polarization and great mistrust of the mailed-in ballot being fomented in certain quarters, that we will have just a real Donnybrook of a fight over what's going on, particularly with the shifting of tallies from one column to the other over a period of time.
Hey,
How was that for?
sounds delightful.
Well, I agree with Paul on all of what he said. I'm neither a prophet nor a forecaster, but the leading indicator might well be the extent of litigation that we're seeing now as an indicator in multiple states of what could happen after November 3rd, or between November 3rd and December the 8th, at least at the presidential level. And that's not taking into account, Senate and congressional and a myriad of other local races on the ballot. So
what is the old cliche that the election officials always pray for not having a close election because that makes their life a lot easier? And
Yeah.
right.
In some ways, I think we should all pray for that in this case. If we really have a state that's decisive and it comes down to a few hundred votes, as happened in 2000, it's not going to be pretty.
Yeah. And there's polling, I think, in the last few days that says that regardless of party, you're not going to trust the result if your opponent wins. I mean, that a very high percentage of Republicans aren't going to trust it if Trump wins and vice versa. So that's not promising.
Yeah.
Could be
And that trust
very
factor, I think one of the themes here, that trust factor, I mean, there's ideology to it, but it's because elections are changing. But Paul said, we Californians can't overemphasize the shift factor. We've been seeing that in elections for a couple cycles now. You see it in ballot measures and statewide officials who were elected, quote unquote, that day. And then over time, it turns. I'm a local elected official, and I'll tell you, everyone gets on the website, right? They're trying to get to this, hitting refresh every day, because it's much more common that elections are shifting slowly in dribs or drabs, Paul, you said it, over time. And that's a new phenomenon. And I think it's going to take a lot for people to get used to.
Yeah, there's not a really clear explanation for how it happens in places like California. The theory, I think, is that Democrats tend to vote later in the absentee ballot voting period than Republicans. That may not be true this year. I hear a lot of talk about people getting their ballots and mailing them in on the very first available date because of concerns about the post office. And if that's true, we may not have the same partisan spread within the mail-in voting period between the two parties that has occurred in Florida and California in the past. but even
I
with,
think it's also very possible that people are much more oh, sorry, Paul, go
I was
ahead.
just going to say, even if that goes away, the fact that the Republicans tend to be more interested in voting in person means that their vote count's going to be in earlier if that
Yeah.
doesn't change in the next 2 months.
But I
The
think
other
also
thing
a
that I,
factor is that voters are so dug in on who they're voting for that they don't care about waiting for the debates. We're not as much as usual.
Yeah, there's not a lot of undecideds out there.
Yeah.
I think there have been some developments in the states about the process of accepting and at least doing the preliminary processing of vote by mail ballots earlier. Of course, the sort of the standard rule has been, even if processed, the results are not tabulated or made available until after the polls close for obvious reasons. But with more ballots in the pipeline, even those efforts to, to have a little more processing time bump up against the fact that at a minimum in almost all states, those ballots can be accepted just as if they were being voted at the polls. And in some instances, the ballots can be received after election day, even if they're postmarked by election day. So,
Chuck, the next slide is yours. You can keep right on going.
oh, okay. Well, talking about polarization, I think this slide sort of introduces that issue, and everybody's heard about claims of disenfranchisement and voter suppression, and one side, and on the other side, issues of voter fraud. The slide provides some information on that. Again, there are kind of competing views of this, and I think that both sides view the evidence and the data and the law regarding fully enfranchising, even at the risk of some potential for fraud, versus opening the floodgates of the election processes to fraud differently. And I think that this affects their view and the litigation is concerned, the extent of the burdens on voting or actual vote suppression, and the potential for actual or potential or actuality for fraud to exist. Estelle mentioned earlier that I think it's commonly viewed, and I think still accepted, that voting by mail presents greater potential for actual fraud than precinct voting. We have a history of fraud in both venues, so it's not exclusive to one or another, but the notion of having polling officials conducting an election at the precinct is one element of protection of the vote. And once it gets out into the mail, there are others, and the question is what those protections are. Typically, vote by mail ballot comes back, contains a signature of the voter, and that affords an opportunity to compare the signature of the voter on the envelope with the voter's registration signature in all but one of the states, which North Dakota, which doesn't have registration. But there are different views on this. The Heritage Foundation has a database of election fraud over time, and the Election Integrity Project, as mentioned, had information on or a study of ineligible voters due to the failure to remove inactive voters from the rolls. Brennan Center has argued that it's a rare situation. What kind of plays against this is the rolls themselves, and so it's not necessarily just a problem of fraud, but the inaccuracy in the voting rolls themselves. Again, there are different perspectives on this, and I think it is probably true that that fraud as a percentage of the actual vote cast is not large, but what is of concern to people more concerned with the potential for fraud is that particularly in smaller elections at the local level, the number of votes needed to affect the outcome is much smaller and creates a real potential at that level for that kind of fraud. And most of the fraud that has been identified indeed has been in local elections. In terms of disenfranchisement issues on the other side, we have over time, both through changes in the law and through litigation, really expanded the franchise, dealt with disenfranchisement issues in a variety of ways. Some people don't think that has been sufficient, and there's still a lot of litigation over it. And so I'm not sure that we can resolve it here. I think it is remains the most significant issue between the different sides, the extent of disenfranchisement, the extent of fraud or potential fraud. And part of this is, unfortunately, that claims of problems in both regards have the effect of driving turnout or affecting the vote. And I don't think we're ever going to see these go away. And the question is really, can the system be adjusted in a balanced way that reduces the dissatisfaction that both sides have, either with potential disenfranchisement or suppression of the vote, and the potential for fraud in the administration of the system or gaming of the system.
I just want to jump in with one thing, and I'm not going to call out who wrote this slide, but the word inactive on the third line, due to counties not removing inactive voters from voter rolls, they're not supposed to remove inactive voters. They're supposed to remove voters who aren't eligible to vote. So just wanted to throw that out there. Any other thoughts or comments on the disenfranchisement versus fraud binary choice, which is not binary?
I think that if you look at the actual objective evidence, it's no serious study that's ever found anything more than a vanishingly small amount of fraud at the polling places, voter impersonation fraud. There have been episodes of fraud in absentee balloting over the years, like the North Carolina election you mentioned in 2018. But that of course got caught precisely because they had the same person witnessing hundreds of different absentee ballots, and it was pretty flagrant. So there are the systems in place that make this much less of a problem than some of the people who are pushing it would have you believe.
I agree. Okay, I think that we have several slides now that Jason's going to discuss on voting issues with particular constituencies.
Yes, and the bridge here is that so much of the commentary and concern in this area has been over the binary choice Chuck just described, disenfranchisement and fraud. But we have examples of two communities here, the Native American community and the disabled community, that make you think a little beyond the binary choice. And the voting by the Native American community could be its own webinar, and in fact has been. So shout out to Jacqueline De Leon, who is on our standing committee. She and I recently did an entire webinar on this with another bar group. The point here is that if you go under the binary mode, more mailing means more voting. That's good. It enfranchises. And if Jacqueline were here, she'd raise up her hand and say, oh, no, 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 no. The challenge here for the Native American community is that more mail and mail-in balloting doesn't necessarily allow more voting, and in fact creates all sorts of complicated situations. The way people live, their homes may not have home delivery of mail at all, and several generations and families are living together. They're very slow mail routes, and there's the use of post office boxes. There's poverty, so just the cost of mailing a ballot. It's not just the way they, the community might be living, but it's the way that they're going to interact with the government. They may drive 90 miles or more to be able to go register, and they may not have a driver's license. Literacy makes signature matches different. There are language barriers, particularly with the elders in the community. Long way of saying that if you get locked in the binary choice, you're going to miss a lot. And the Native American Rights Fund is involved in litigation in a number of states to try to address this. And if people are interested to look on their website, they just released an entire study outlining these issues called Obstacles at Every Turn, Barriers in Political Participation Faced by Native American Voters, with a series of proposals that they'd like to see, but an emphasis that mail is not the answer. And so we've talked in the webinar about people's preferences about voting in person or not. Here you have a community where you have to, whether by voting centers or they're even advocating curbside voting and more drop boxes, mobile voting, to reach people who just aren't in our urban centers or in suburban areas that have easy access to voting or to the mail itself. So I think that's a important point to be made, and complicates the analysis when people get stuck in the binary.
Let me just also make a plug. There's another webinar on this subject in depth that the section of Civil Rights and Social Justice is giving on the 1st of October. And if you want more information, I'm not sure I even have the time, but it also features Jacqueline de Leon of the Standing Committee on Election Law, among others. And if you want more information, go to the website of the section, Civil Rights and Social Justice, and you'll find it for sure.
There you go. And she'll say it much better than I. But relatedly, and I know we're tight on time, I've already mentioned disabled voters to some degree before, and gave a shout out to Hawaii system. And of course, there's more litigation in Wisconsin if we had Megan here over the issue. The bottom line is the challenge of the communities. And this Pennsylvania situation is pretty notable because there was a real challenge getting any accessible write-in ballots for voters. And they came out only on May 28th before the June 2nd primary. And of the estimated 155 state residents with visual disabilities, 26 applied for and received the ballot. So there's continuing litigation out there, and frankly, some outrage about getting access to voting by mail. And that's why I mentioned before the Hawaii approach, which I think has great promise. The use of technology, the ability for privacy in voting, I think is something to keep an eye on.
Okay, want to talk about gender parity now?
Yes, we get to do another plug, Estelle. We like doing our plugs. The committee also just recently co-sponsored a CLE as a part of its efforts of not only celebrating the 19th Amendment, but looking in a modern lens at gender parity in the electoral process. And again, since it's the topic of an entire other webinar, I think the takeaways are when you have 50% of the public that are women, and 24% in Congress, and sort of almost a myth that it gets better as you get further down. Well, that might be true. I mentioned before, I'm on a school board and I'm the only male, but even in state legislators, that number only reaches 29 to 30%. So, the question is what to do about that. And the committee is hoping to spend some time on that. I'm just going to say really quickly that in the webinar, if you're interested, we talked about what other countries are doing with quotas, what California is trying to do on corporate boards and whatnot. What do you do to benchmark or standardize? We talked about campaign finance laws. One of the members was an advocate on allowing for childcare coverage for your campaign, using your campaign funds for childcare coverage. We talked about what's happening in legislatures, sexual harassment rules, and barriers when the public is interacting with their public officials. And we talked about government ethics laws that were written really for a different time when there was a wage earner and a conflict of interest because of it, and with different gender roles and different gender identities. What kind of barriers do these laws put in place that make it difficult for women to run for office and to hold office? So, another area for a lot of focus. That's not an election administration problem, but it's them getting, women just feeling comfortable in running for office and in serving.
Thank you. So we only have another second or two, but I wanted to wrap up by saying that obviously the issue of election administration is a complicated one. It is driven by states. There are literally thousands of election jurisdictions in this country, and there are sometimes big and sometimes little differences among them. So education and research is very important. Our guidelines are designed to cover a multitude of issues. I think you get that sense from what we've been talking about. And we're always welcoming more suggestions. If there are things left out in here after you look it over and you'd like to make a suggestion to our committee, they will undoubtedly be revised again within a few years. I think especially with technology changing as it does, and maybe the COVID temporary fixes might end up being more permanent than temporary. So I think that, these things bear a lot of watching. It's in everyone's interest for elections to run smoothly and to be fair. And I think that this committee shows, among other things, that we can talk sensibly and rationally about this without the rancor we see in so much of American political life. And if you're interested in the work of the committee or want to try to be on the committee, it is an ABA presidential appointment, and you apply in, generally it's February. So I urge you to get involved. I urge you to join the ABA if you haven't, and join the section of Civil Rights and Social Justice in particular. If you're interested in this issue, I'm sure you'd be interested in that. Without further ado, I think we should probably sign off, and thank you all for participating. I'm sorry we didn't have time for questions.